And good afternoon to the attorneys. I am Judge John McClarty presiding. We have Judge Bryson and Judge Davis. The three of us will be sitting on your panel this afternoon. We will be proceeding as if we are in court. However, you will not need to stand unless you so desire in your presentation. I assume that the time has already been reserved for rebuttal.
Yes, Your Honor.
Okay. In that case, we can proceed. Mr. Clerk, before we proceed, are there any preliminary matters that we need to consider?
No, Your Honor.
In that case, will you call this case, please?
Angela Michelle Cela versus Sokol Cela.
For the plaintiff appellant, you may present your case.
Thank you, Your Honor. My name is Roger Manus. I'm the lawyer, one of the lawyers representing Angela Cela, the wife in this matter. I'm joined today by my colleague, Katie Klinghard, who actually tried the case. I'm on appeal on the case, but I didn't actually participate in the trial of the case. But Ms. Klinghard was kind enough to allow me to work on the appeal with her. It's been an interesting appeal. The way I would like to address this is my adversary, the appellee in this matter, raised a number of issues in their brief of appellee that I attempted to address as best I could in my reply brief. And right off the bat, I'd like to ask if the court has any questions about those issues, because if not, I want to proceed straight into the what I consider to be the crux of this appeal. So
I hear no questioning, so you may proceed in your manner you want.
all right, thank you. This case presented an interesting scenario in a number of ways. As I pointed out in the opening section of our argument in our brief of appellant, Miss Cela was difficult in some ways, certainly for Miss Klinghard as a lawyer in this case. Now, we've very candidly acknowledged that in our brief of appellant. The trial court held Miss Cela in both civil contempt and criminal contempt, ordered jail time and a substantial judgment, which was later paid. And it was plainly obvious from reading the record that the trial court was probably appropriately put out with Miss Cela and some of Miss Cela's behavior during the case. That being said, we don't believe it was appropriate for that to carry over into the property division. Now, there's no expression of that, of course, in the court's opinion, but there were two components of this property division that when I read the record really stood out in my mind, and one of which, of course, is the valuation of the marital of the business of Miss Cela's speech pathology business. Now, on that one, that was of tremendous interest to me. I have worked on that issue a lot in the past, and the thing that I found remarkable about that was that both Miss Cela's expert Michael Wallace and Mr. Cela's expert Mr. Hedrick essentially agreed that in order to get the value under the income approach that Mr. Hedrick came up with, Miss Cela would have to be contractually bound to a buyer, either in the form of an employment agreement or a covenant against competition, or both. Now, I don't think Mr. Hedrick fully understood that, the importance of that tacit admission on his part, because he made a curious statement that's in the record. He said outside, when he was discussing the three types of valuation, he said outside of a Tennessee divorce, there are in which the asset approach is normally used. there are the income and market approach. Well, we're not outside of a Tennessee divorce. We're squarely within a Tennessee divorce here, involving a single member LLC, essentially a sole proprietorship in it. And so we can't step outside the type of case that we're in on it. And then later on, he said, well, I think in this case, this is a true business. I'm not really sure what that means. Of course, it's a true business. But the crux of the thing is that nobody, Mr. Hedrick did not address the issue of FNSing goodwill in his testimony. He seemed to assume, or I say he seemed to assume, he did assume, for purposes of his opinion, that Ms. Cela would be required to sign a covenant not to compete. That's just an assumption that the expert is not entitled to make in a case like this. There is no covenant not to compete for obvious reasons. She's a single member LLC. She wouldn't covenant not to compete against herself on it. And he's just not entitled to make that assumption under our case law and our authority. In the cases we've cited, the Ogle case and the Duke case deal squarely with that issue. Both of them do. Now, Ms. Klinghardt got her teeth into him in cross-examination and went at him pretty hard on this issue of the covenant not to compete. And at some point, Mr. Hedrick, made the statement, well, it may still have a value of $790,000 without a covenant not to compete. I locked in on that because I've tried a lot of cases over the years. May have a value, won't cut it in Tennessee law. It won't cut it for an expert witness opinion. We require in Tennessee, when an expert witness gives an opinion, that his opinion be more probable than not, or more likely than not, or words to that effect that indicate a measure of certainty, a probability, not a possible, as opposed to a possibility. The word may denotes a possibility on it. So it seems to me that there was the primary failure here was the failure of Mr. Hedrick to comprehend the importance of that assumption on his part, and the failure of the trial court to comprehend it, and the failure of the trial court and its memorandum opinion to address that. So the trial court just kind of stepped around that. It ignored that FNSing goodwill problem. There's simply no reference to it whatsoever in the trial court's opinion on this matter. The trial court, interestingly enough, relied on what's the Maybe case out of Memphis, which it seemed to me was really inapposite. It's an unusual case in which one side elected to go with a shareholder agreement formula for valuation, wound up with an $8,000 valuation of an interest in a pulmonary group in Memphis that throws off $72,000 a month in income for the doctor that owns the 1/12th interest. So that was very unpersuasive, it seemed. Now, I'm down to 2.5 minutes, it looks like, on my time. It always gets away from me in these matters. But I'd like to address briefly this military retirement thing. There are two components, we believe, to the court's failure in that regard. And one of them is simply a mathematical error, which I don't believe, I've not found any authority for the proposition that a mathematical error is entitled to a presumption of correctness. The math is what the math is. No real effort was made in the brief of appellee to address the mathematical error. So that in and of itself seems to be fraught with potential for reversal. The other area, it did involve the court's discretion, and that was the 48-month reduction in the wife's period of coverture. And I found in that the court's language to be very troublesome in that the court really assigned to Ms. Cela a role of a passive, casual, free rider in this thing. Now, there's no dispute here that she was a good mother and that she had a strong work ethic and took good care of the children. Mr. Cela made a choice to be a pilot. And yes, she went back to school while he was in the military, but he reaped as much benefit from his military career as she did. And so there was an inconsistent application of the standards of Section 121 that govern the division of marital assets there. And there's just, it seems the only explanation that I could find for that inconsistent application and that fairly radical reduction was that it was punitive. So I'm down to 10 seconds. I'll be happy to answer any questions that the court has at what little time I have left.
I don't hear any. You do have your rebuttal time, though. Thank you very much, sir. The plaintiff appellee.
Yes, sir. Good afternoon. I'm Mark Olson, practice in Clarksville, Tennessee. I appreciate you all hearing us this afternoon. I'm going to address the issues in the order in which they were presented by Mr. Manis's brief, and then in the last few minutes that I have, address some of the relief that we would seek. First, the issue of the military retirement, in my estimation, is in large measure resolved by the very fine decision that was written by the judge in this case. The judge provided a very lengthy memorandum that was well crafted, in my opinion. It left me no questions that I could even submit a Rule 52 motion on that I recall. Maybe I did, but I often know when a case is going to go before the Court of Appeals, I'll ask for more information about how the court reached a decision. In this case, I didn't feel that was necessary because the decision on all points was very well reasoned. The memorandum opinion of the court, pages 36 through 37, really it's the meat of what was discussed with regards to the military retirement. In that case, the court found that it was appropriate to reduce the military retirement for several reasons. Those reasons, and just to hit the factual parts, were number one, the wife chose not to follow the husband. He was in the military. He was forced to live in different states. The wife chose not to do that. Now, she stayed here at the home that Mr. Cela provided even during the time she was in school. And I think that the court was very taken by the fact that the husband, in an effort to provide for the family, provide for the wife, lived in a camper for a number of years so that the wife would be able to maintain a home here because she didn't want to follow. The court also took into account the fact that during the time period that the husband was in the military, as a result, gaining his military retirement entitlement, the parties were separated. And in that case, and I'm not trying to beat up on the wife, but this was a fault-based decision. The wife was found to have engaged in activities which gave rise to fault, and the court found that the parties separated during the time period that the husband was in the military, and that the court found that that was not an appropriate basis to award a portion. So the court reduced by a number of months the percentage that the husband would, or that the wife would be able to get from the husband's retirement. And I feel like that was very well set forth, and I'm not going to address that anymore unless the court has questions. Moving on to yes, ma'am.
Olson, what about the mathematical error that
I didn't see a mathematical error, and because it is my impression that what was done was there was an attempt to include, and I may be misreading this because I'll be honest, I didn't spend a lot of time on this portion of it. I spent a lot of time on our valuation issues. But what we had was, and I think that this was cured by the provision of our brief that outlines the time that the parties were together. My client was in the United States Marine Corps before the parties married. Then he was in the United States Army. So what you have to do is, in addition to excluding the portion of the retirement that the court found appropriate to exclude, you also have to exclude the portion of the retirement that was accrued during the time that my client was a Marine and the parties were not married. And from my memory, that was, I thought, the explanation with regards to the manner by which the factors were done. And I think if you look at the memorandum opinion, again, on page 36 through 37, there can be some errors, but I think the findings were very close, or very, very carefully set forth. Husband's credible months in service, 249 months, time married while in service, 119. And then the court above that discussed in significant detail how the court came up with that. So I did not see that as an error. I felt like perhaps counsel was mistaken in that regard, and I can be corrected. But moving on, then, if we could, I feel like this was one of the more interesting valuation cases, and my impression is that the grievous error that the wife's expert made was, and I would commend this to experts, having worked with a number of experts, leave the law to the lawyers, formulate your opinion. Because as you read the experts' report, he spent the majority of his time discussing what the law was in his mind rather than discussing his findings. And basically, we're here today to kind of determine what the law is. And as the court is aware, there are three different ways that have been recognized by our Supreme Court, by Court of Appeals, to look at the manner by which a value should be established. Goodwill comes into play with regards to valuation as a matter of discount. The expert, Mr. Wallace, made an error, in my opinion, by trying to rely on cases where there was an individual doctor, there was an individual practitioner who ran his practice and was, in all estimation, a real live, true sole proprietorship. We felt like that was greatly undercut, and the court accredited this testimony by a Rule 1006 summary that we submitted. It's an appendix to our brief at 127. It's on page 1001 of the actual transcript, where what we did is we just took and we got this literally the week before trial, and I understood why when we got it. We took the W-2 employees of the company that was at issue, and we went through that very carefully and found that there were, and this is from memory, and it's in the brief, there were 46 employees. Out of the 46 employees, 21 of them, and we've identified them, were what we would consider professional staff. Of that professional staff, there were a number of those employees who practiced in an area that was separate and apart from the area that Mrs. Cela practiced. So what we had was, in my opinion, and I commend trial counsel for doing their very best to shoehorn a bad set of facts into the law because it would have been helpful to them. You do not have a sole proprietorship here because you have a number of employees, and more than just the number of employees, you have a number of employees who are professional, who are providing services that the individual who is allegedly a sole proprietorship is not allowed to do by application of law. She is a speech pathologist. She is not a physical therapist. She is not an occupational therapist. She does not provide ABA therapy, which is very, very needed right now with folks who are young children, particularly, who have difficulties with behavioral things. So she doesn't even provide those kinds of services. So what we were left with was, the idea that we have to try and shoehorn that into sole proprietorship. And that's why I say Mr. Wallace, in my opinion, was mistaken, should have left the law to the lawyers, because what he did then is he ignored the other manner by which you could value something. And what the court found, and this is really true, Mr. Wallace assigned to the value of the company a liquidation number. I think it was $82,000 is what he determined the value of this business was. as we put in, and we have and I commend the court to the record, we put in a Rule 1006 summary of the actual income. This company was running several $1 million at different times in gross revenues. The wife was taking out anywhere between $200,000 to $360,000. And again, those are in gross round numbers, but that's what the record demonstrated. The idea that this was worth $82,000 came from the idea that this was a sole proprietorship that could not be valued with regards to goodwill. The court saw through that, and in a very well-crafted decision, in my opinion, said, I tell you what I'm going to do. All these people who are over here who are doing work, including work that you're not licensed to do, I'm going to take the percentage of their income and I'm going to apply that to valuation based upon, in large measure, the sale of other businesses that are similar businesses. But I'm going to take out your percentage of billings. Now, several points there that I thought were important. Number one, the name of the business was not Angela Cela. The name of the business is MTW. It was originally More Than Words. It became something else, but the acronym MTW was very important. Second, as Ms. Cela testified, she was opening these businesses in other locations in other towns. That's something that is not a sole proprietor. That's not Mr. Manis or Mr. Olson with our shingle hanging out on the street hoping someone will come by and hire us. That is an entirely different deal. What Mr. Hedrick did then was he looked at comparative sales. He looked at it and said, I'm going to look and research sales of the same kinds of businesses and determine what the values were that they came up with. Mr. Hendricks then reduced that down by some factors that are discussed, and I won't go through that because we're running out of time. But he came up with a value that was $790,000. What the court did was accredited that value in essence and then reduced by 14.3%, which was the percentage of gross revenues that the court found was generated by Mrs. Cela, and said, okay, we're going to give you that. And the thing that I found interesting about that as I read through it and I looked at the case law, that's directly in accord with what the case law says. The case law from your honors and from courts of appeals and past says very, very clearly, look, Judge, you're going to be presented with a range. And that range is something that you have to take into account and make a determination based upon the factors in valuation. And that's exactly what our learned judge in this case did. She looked at that. She came up with a value based upon the range. And in part, she bought, I personally felt it was probably an error, but I understood the logic of it, to decrease the value of the company by this nice lady's billings. The reason I felt like that was probably a mistake was the company went on even during several times when she took extensive sabbaticals and were no longer there. But anyway, that I feel like Josh Hedrick's decision, or not decision, but opinion with regards to his value was very well thought of, and it was supported, in my opinion, by the case law, and it was, in my estimation, supported greatly by the fact that he looked at more than one way to do valuation. If I can, we've got a couple of minutes left. If I could just address a couple of issues that I think really the court could help us with considerably with illumination. First, the final issue brought up by Mr. Manis, I don't feel like the manner by which they're trying to approach this third issue, the equities of the situation, they're bringing in things that are respectfully just not part of the record. The court has to look at the record. We can't then go make up stuff. We made up stuff, to the extent you want to call it that, by taking documents that they provided us and giving them Rule 1006 summaries that were then accredited by the court. That's not making up. That's evidence the court accepted. What they're doing is trying to bring something in post-trial that's not appropriate. If I may just address a couple of the issues that we have that continue on that are presenting difficulties. Number one, this lady was remarkably difficult throughout this action. She refused to pay support. My client was damaged dramatically. And I'm going to be candid with you. This divorce was probably 100% more expensive than it needed to be because of the recalcitrant actions of the wife. We think that it would be appropriate, as we've outlined in our brief, that she have been ordered to pay a part of our attorney's fees. Two, there was an alimony insolito award that was made to divide the property, specifically the interest of the business. Mrs. Cela gets the use of that business now without deduction for value. My client takes his over the next few years. We believe interest should have been awarded. Second, we've had great problems with Mrs. Cela paying the alimony insolito. She's been better, but it's been difficult. Every time we go to the court and counsel says, hey, that's every time that's brand new. We think it's a judgment. It should be accelerated just like any other judgment if she doesn't pay. Third, fourth, we feel like the attorney's fees on appeal should be awarded. And fifth, just briefly, I'd ask the court to look at the calculations we came up with. I think that if you want to look at number problems, it's the income of the wife that was attributed by the court. And I see my time is up, and I know you've had a long day. I don't want to run my mouth too long. Thank you all very much for considering our argument. We appreciate it very much.
Thank you, sir. Your rebuttal?
Yes, sir. Thank you, Your Honor. In my brief of appellant, I pointed out to the court that the trial court, in its 38-page memorandum opinion, had failed to address the problem of evanescing goodwill. Well, one would have thought that, having been confronted with that in the brief of appellant, that it would have been addressed in the brief of appellate, but it wasn't. So in my reply brief, I pointed out to the court that it was ignored by the trial court, and now it was ignored again by the appellee in the matter. And now, today, after 15 minutes of argument by the appellee, I stand before this court and point out to this court that after a third opportunity to address the concept of evanescing goodwill in a sole proprietor not bound to the company by an employment agreement or a covenant not to compete, there's been no effort to address that. It's gone unaddressed at every level: trial court, brief of appellee, and now an oral argument. That's the elephant in the room, if you will. Nobody wants to talk about that. Mr. Hedrick just made an assumption that you're not entitled to make. Now, Mr. Hedrick maybe should have read. He actually testified, and I put this in my statement of facts, that he did not consider any of the Tennessee divorce case law in forming his opinion. Well, he should have read it, because if he had read it, he would have seen that that's a very important concept. And all of this talk about the number of employees and locations and all of that, a simple reading of the Ogle case, which is a single member LLC, electric company. No way Mr. Ogle did all the work that was done by that company. And more importantly, the Duke case, Dr. Duke owned a company in the Duke case that that provided physician services to emergency rooms all over the state, all over the Southeast, I think. And no way that all the billings that were generated in all those emergency rooms in Knoxville and Memphis and in Birmingham or wherever were generated by the services of Dr. Duke going out there and meeting with patients in those emergency rooms. He was the owner of the business. He was the sole owner of the business, but other people were doing the work in different locations. Exactly what counsel complains of in this case as being demonstrative of the fact that this is not a sole proprietorship. It is a sole proprietorship. All those things they conflate other issues that have nothing to do with ownership. In this case, this business, this speech pathology practice, is owned by one person. She walks out the door tomorrow, takes her employees with her, she takes her contacts with her, all those things, and opens up a practice across the street and goes into competition. That's where the goodwill goes. That's the personal goodwill that that has to be evaluated by a buyer in purchasing this business. And so, as Mr. Hedrick pointed out, and as Mr. Maggart pointed out in the Ogles case, I mean, if any buyer that comes along is going to require a covenant against competition, and that is simply not a fact that's in existence at the time of trial. It's speculative to assume that Ms. Cela would ever agree to any such thing. And since it's not a fact in existence at the time of trial, it's not appropriate for consideration. It's not appropriate for Mr. Hedrick to assume that fact into being in terms of his evaluation. So this issue of the range, I want to address that briefly because I expected that to come up. This issue of the range of values, you can always go out and find somebody to testify to a number out here. But that person's testimony has to be based on sound reason and based on the law. And that's where Mr. Hedrick breaks down in this thing. He said, it seemed like a nice fellow from reading his testimony. Ms. Klinghardt actually met him. I didn't. Seemed like a really nice fellow. But frankly, he should have read the case law, and he would have known that that's an important concept, the concept of evanescing goodwill. It wasn't addressed appropriately by him. He made assumptions he shouldn't. And everybody else has tried to avoid discussing that right up until today.
Well, thank you very much, sir. I want to thank the lawyers for your presentation. Your case is now submitted to the panel, and the lawyers will receive our opinion and our ruling on this case in a due course of time. Again, thank you. The lawyers may be excused.
Thanks, sir.
This honorable court is now adjourned.